good afternoon, everyone. Thank you for joining us today for webinar series, Legal Planning for Specialty Crop Producers. My name is Chloe Marie, and I am a research specialist at the Penn State Law Center for Agricultural and Shale Law. And as we are getting started, I would like to provide a little background on the center's organization. Our director is Rose Pfeiffer, Jackie Schweckler, Audrey Thompson, and Brooke Durer are our staff attorneys, and in a couple minutes, you will meet Brooke Durer. Here at the center, we provide numerous resources for agricultural legal stakeholders through our website at aglo.psu.edu. And if you'd like to learn more about a specific topic in agricultural law, please check out our agricultural law virtual resource rooms and issue trackers. Our issue trackers are similar to our resource rooms, but provide more of a timeline of developments for a specific topic. And for more frequent updates, you can subscribe to the Agricultural Law Weekly Review. You will receive a once-a-week email with all the most important updates in agricultural law. But if you would rather listen than read, you can also subscribe to our Agricultural Law podcast. Our podcast can be found in all the usual podcast streaming platforms like Spotify, Apple Podcasts, Google Podcasts, or directly on our website. And again, to get to it, go to aglo.psu.edu. And in addition to our other agricultural law resources, the center operates the Pennsylvania Agricultural Mediation Program, which is funded through the USDA. This program is free and has facilitated mediations between ag producers and the USDA, but also between different parties. Jackie Schweckler, one of our staff attorneys, is our program coordinator. Please feel free to reach out to her with any questions you may have about mediation. So the Legal Planning for Specialty Crop Producers webinar educational series has been designed to assist Pennsylvania specialty crop producers successfully expand wholesale sales revenue with income from direct sales, PQ on value-added commodity processing of agritourism, agritainment, and educational activities. And over the next few slides, I have listed the 6 topics in this legal planning series. The last 4 presentations have passed, but as I mentioned, as registrants, you will have access to those recordings. If you have trouble finding the recordings, please let us know and we will forward them to you directly. So today's presentation will be about municipal law and zoning for agritourism with specialty crop processing and sales. And please mark your calendar for the next and last presentation, which will be held on December 14, 2022 at noon via Zoom. It will be about Pennsylvania Ag Area Security Law, Right to Farm, Acre, and Clean and Green laws for specialty crop producers. And also, earlier this year, we started a webinar series called Understanding Agricultural Law, which is a course of webinars designed to provide education on fundamental issues of agricultural law. This series is fully sponsored by the Pennsylvania Department of Agriculture's Ag Business Development Center. And on this slide, you can see a list of our future topics. And the recordings are available on our YouTube channel if you're interested, but you can also register for our next sessions through the event page of our website. And before I hand it over to Brooke, I would like to throw a quick thank you and know that this presentation was created as part of the Pennsylvania Specialty Crop Block Grant Program. And I would like to draw your attention that near the end of this program, we will post a link in the chat to our specialty crop producer survey. It is a short survey and should only take a couple minutes of your time. Please consider completing the survey as these surveys help us out a lot. Not that they're different for each webinar. So if you filled out the survey for the last webinar, please fill it out again. And in a couple minutes, we will also post a poll questions asking about how you have heard about this webinar. This is different than the survey questions, so please do both if you're able to. I will now turn things over to Brooke.
All right, thank you, Chloe. I hope everybody can hear me and see me, and I'm sharing my screen. Right now we have the title slide, Municipal Law and Zoning for Agritourism. Somebody gave me a thumbs up here, so it looks like we're good. All right, so that's what we're going to talk about here today. primarily zoning, but a couple of other things that come into play. And some of this and what we're going to talk about is formed by the fact that I was at the Department of Agriculture for a number of years and had very recurrent calls about issues that people were having dealing with their local township. And so some of the things we're going to talk about, particularly towards the end, are sort of the highlights or the greatest hits from those kind of calls. And of course, here at the Ag Law Center, we get even more of those kind of calls. So that's where I'm sort of highlighting is things that have come up over and over again. It's a really broad topic. And so we could be here all day talking about lots of things, but I just had to whittle it down a bit to cover just a finite number of things that I think are important as your takeaways. One thing we're not doing here is going to walk you through like how to conduct yourself at a zoning hearing or something like that, because that's a whole nother story, a little bit hard to convey when you only have an hour and we got a lot to talk about and make sure that you understand. So with that in mind, again, this is topic 5 of our entire series, and our entire series has been essentially all about liability prevention. That's the goal of what we're trying to get across here. And whether it's liability prevention from some kind of civil liability or some type of regulatory liability here that I have on this slide listed, that's kind of what we're gearing all of the presentations to, so that if you digest and learn the different things that we present here in this entire series, hopefully you are much better off in terms of conducting your business and being free from liabilities. And again, that includes not only civil liabilities, like somebody gets hurt, on your farm because they're participating in pick your own operation or whatever it might be, but also regulatory liabilities. And now we talked a little bit about criminal liability. It's not what we're going to talk about here. We've talked about them just to essentially distinguish them from what we're talking about here. So this is just another form of regulatory liability. And here's a slide that I have used in the past in this series, and I'll just use it again to essentially put these things in context in terms of the types of liabilities that we're trying to address here and prevent you from essentially having some type of a business problem arising from one of these. Let's assume, just as an example, that the farmer operates a pick your own strawberry operation, and a chronically leaking manure pit discharges into the strawberry fields where every spring the strawberries grow, contaminates the soil, and the strawberries also are contaminated, and several customers become ill. Okay, so could there be a civil liability? Well, yes, that's the kind of traditional thing that people think of when they think about liabilities, which is somebody brings a claim saying they were made ill by a product that they purchased and consumed from a producer. So, and again, this is all specifically trying to gear it to specialty crop producers. And that is our target audience, by the way, for those of you who are out there, not lawyers. We had last week, somebody asked for the continuing legal education credit code word, and we're not offering, this is not a target presentation for lawyers. This is at the layperson's level. I try to bring everything down so that actual producers can understand what we're trying to get across. So certainly there could be a civil liability in our example here. Could there be a regulatory liability? Well, probably, obviously we're talking about a leaking manure pit here, and I added the word chronically leaking. So there's some longstanding issues there, which could lead to some problems with liability from a state regulatory standpoint, DEP in particular, with regard to the manure pit. Now, could there be criminal liability? We've already talked about that. Very, very rare. There have been some high-profile recent examples of particularly food contamination cases. There's the Peanut Corporation of America, which was several years ago, where high-placed executives in that company were charged criminally because they continued to push product out the door, even though they knew that their factory was chronically contaminated with various pathogens like Salmonella, E. coli, et cetera. Now, the one that's making all the headlines in the last year, let's say, is the I think it's Bluebell ice cream. And Bluebell ice cream is, I think, from Texas. And there was also a problem with a chronically contaminated production facility that the company made the decision to just continue on and continue manufacturing and selling ice cream without remedying the problem completely, and with full knowledge that they hadn't remedied the problem. And there is criminal charges pending, and you might have heard that there was actually a mistrial in the first one. So they're going to have to try, or at least in one of them, then they'll have to try some one or more of these executives at that Bluebell ice cream company again. Okay, so today's question, the twist that we're adding to talk about today in the zoning and municipal law context is, okay, now, is this pick your own strawberry operation a permitted activity at this particular site? And that's a municipal law and zoning question. So that's really another form of regulatory liability. So, again, last week we talked about licenses required for food processing, storage, and sales from whatever entity enforces food safety in that jurisdiction. And we talked about the fact that there is a retail food facility license for the retail sales of specialty crop products, raw, depending on what else is sold with them, as well as processed specialty crop products, and that there's a food establishment license for things that do everything else with regard to storage, transportation, et cetera, of food, but not maybe delivering directly to the consumer at that location. And we talked about the fact that most of the state is covered for food safety requirements, and the food code, the national FDA's food code, is enforced in Pennsylvania by the Department of Agriculture, except in specific jurisdictions that have local health departments. And there actually are a number of counties and smaller municipalities that have their own health codes and do their own enforcement and licensing of retail food facilities. The manufacturers are all licensed by the Pennsylvania Department of Agriculture. In any event, this week, we're going to talk about local permitting, primarily zoning, for the operation of supplemental income generating activities at the farm and the homestead location. And again, this generally takes on zoning, but could be other things. And the supplemental income generating activities that we're going to talk about can be all over the map. We've been talking in this entire series about direct sales, agritainment, agritourism, all forms of those activities to generate supplemental income. A lot of what we're going to talk about does come around to direct sales, but it's meant to be much broader than that. Okay, now I'm going to talk about some resources real quickly. Here's a really, and these are all linked. If you get our website, you get this PowerPoint from our website, you'll be able to click on these various links, anything that's underlined in blue like this, and get these documents. The key document, the key resource in the entire Commonwealth of Pennsylvania with regard to zoning requirements is called the Municipalities Planning Code. And that is the enabling legislation that authorizes and allows local municipalities, whether it's a county, a city, a township, or a borough, and those are the categories of municipalities that exist in Pennsylvania, any one of those can actually be responsible for enacting, administering, and enforcing zoning ordinances. Now, we happen to have a state where, for the most part, zoning ordinances are enacted, administered, and enforced by cities, townships, and boroughs. However, counties can adopt them, and so that's at least they can write them and enact them, and then townships may wish to opt into that or not. So they wouldn't be technically, the county would not be enforcing, but they would be enacting and doing some bit of the administration. Now, there are some other things that we're going to talk about that are also covered in the Municipalities Planning Code. You'll see this abbreviated as MPC, and people will say things like the MPC says this, particularly if you're talking to a zoning officer or somebody of that nature, they may use that phrase. So that's what it means. That's the overriding law that controls all of zoning and authorizes zoning in the first place in Pennsylvania. There are also things like subdivision and land development ordinances, which also are authorized by the MPC, and we'll talk a little bit about those. Here's some other great resources. Center for Rural PA has published a thing called Agritourism Business in Pennsylvania, a resource handbook. And here's how you get that by clicking on there. Center for Rural PA is a branch or an entity of the Pennsylvania General Assembly. This is only a couple of years old. This is the second edition. There's also a thing on the pa.gov website that is called the Business One-Stop Shop, which has a whole search function in there that if for some reason you don't know, or you need to find out about some other location somewhere else that is not your home location, but you want to find out who is the zoning regulator in that particular, for that, like a street address, you can actually just pop in a street address in this search function, and it will give you the information as to who's the township or borough or city, or where it's located. In other words, what jurisdiction has authority there, and then give you the addresses of all the officials in that township so you can contact them, and phone numbers and things. That's kind of a nice thing. Lancaster County Planning Commission has published two things that I think are really helpful to this exact topic. They're applicable statewide. One is called Agritourism Guidelines for the Promotion and Regulation of Farm-Based Tourism Enterprises. And that's this one that's sort of in the background here. And then there's another one that's a little bit newer called Agricultural Zoning District Guidelines for Lancaster County, Pennsylvania. And that is a discussion very specifically from sort of the planning commission of the county to the county's townships about what are features that they should consider for their agricultural zoning district requirements. And that's a really nice, insightful document that has a lot of great things in it. You can really learn a lot by reading these things. And you see examples of ordinances, which you can compare with the ones that might be in existence in your area, in your township, whatever jurisdiction you're in. All right, this is a whole slew of resources that are published by what's called the Pennsylvania Local Government Services Center. It's part of the Department of Community and Economic Development, and they have one that's just on zoning, one that's all about zoning hearing boards, one that's about specific procedures in front or proceedings in front of zoning hearing boards, special exceptions, conditional uses, and variances. There's one that's just about zoning officers. Don't have that one pictured here, but you see they all look the same anyway. And then there's one called Planning for Agriculture, which is more about planning issues than specific zoning. But also is very, very helpful to understanding some of the things that you may get impacted by in your operation if you're looking to branch out from, just standard wholesale sales revenue of a commodity. In other words, direct sales and other types of sort of more innovative income generation. So there's all kinds of great resources out there. I'm just going to skim along the surface here and tell you some very big issues that you need to be aware of and know about and get you familiar with some of the terminology. Okay, we're going to talk about zoning. And the question in zoning is, the primary question anyway, is the land use, the use permitted? So you got to get used to using the concept of a use as more or less a noun. A land use is a category of things that you might do on the land. So is the use permitted? That is the principal question of zoning. Is the use that is in fact going on here with all of its attributes permitted at this particular location? We're also going to talk about Uniform Construction Code, which is any structure utilized that is it sufficient for occupancy by the public? And that's what the Uniform Construction Code is. People understand that there is an ag exemption. I'm going to talk about that at the end in some detail so you understand it. So that is very important because generally a barn, a historic barn, or even a modern barn is not actually legally sufficient for occupancy by the public unless it is compliant with the Uniform Construction Code. If the public is coming in, and so that's that's an issue that is led to a lot of trouble and problems with everything from wedding barns to people just trying to do simple retail operations, et cetera. We'll talk a little bit about subdivision and land development ordinances. what they are exactly and when do they come into play. And we'll talk very briefly about Stormwater Management Act requirements, which is another thing I've seen over and over again that small producers who are looking to branch out into other things get tripped up by. And all of these things, subdivision land development ordinances and Stormwater Management Act requirements, which basically means a stormwater management plan most of the time, can be expensive. That involves retaining engineers and doing all sorts of, drawings and, computations. And so these are expensive undertakings, getting involved with number 3 and 4. And of course, the Uniform Construction Code, if you have to retrofit a barn or something to be compliant with the UCC, is quite an expensive undertaking. Okay. And of course, zoning ordinances can have requirements that can be expensive to comply with too. Okay. So what's zoning? It's basically the regulation of land uses, as I said, and the individual requirements like setbacks and what we call dimensional requirements, or how many, how dense can you have development if it's residential units, or what are setbacks if you're have a building for the public to use, a retail operation, let's say, and all those kind of things, are there minimum lot sizes, etc. Okay. The MPC controls the whole zoning process. Now, there's an interesting buried nugget in the MPC, right in the purposes of the Act, which I love to impart to people for this purpose and this purpose only. Doesn't get you very far, except when you're in a tight spot and you're dealing with a township who is seeming to give you a hard time about something that you think is relatively unimportant in the grand scheme of things. And perhaps they need to be reminded that the purpose, or one of, I should say, the purposes of the municipality's planning code, I'm just going to read this here, is to ensure that municipalities enact zoning ordinances that facilitate the present and future economic viability of existing agricultural operations in this Commonwealth, and do not prevent or impede the owner or operator's need to change or expand their operations in the future in order to remain viable. It's exactly what we're here to talk about, those exact things, those income expansion opportunities that you can potentially pursue as a specialty crop producer. And this expansion, is exactly what this industry is undergoing right now. So this is good language to remind a zoning officer who might be giving you a hard time about your project. Remind them of this language, or make sure that if you have an attorney or somebody who's doing work for you, that you incorporate that in things that you file with the township. That's a nice little thing to know exists. I think most township officials would not even know that that language is in the MPC. Okay, now steps to understand your land's zoning requirements. This is sort of a walkthrough. This is the path that you need to follow. First of all, you got to get your hands on the township's current adopted official zoning map. And that is generally always available online. Most townships now have a website of some kind, maybe very primitive, but they have it. And they generally almost always have their zoning ordinance available for online viewing. Otherwise, you got to buy them. I was a lawyer back in the days when you had to buy the zoning ordinance from the township, and they would charge you $25 to give you this little booklet with a copy of the zoning map in there that you would fold out and everything. Now it's all online. So you identify your zoning map and you get that. You identify the zoning district in which you're located on the map. And then that allows you to go from there. That you can look up in the zoning district that you're in, you look up what are the permitted uses. So that's always the most fundamental thing, is what is your use called that you are intending to pursue in that particular township. A lot of times terms for what is being done in the way of supplemental income and agritourism and agritainment activities, a lot of times zoning ordinances have not caught up to that. So a pick your own strawberry operation or a pick your own pumpkin or whatever, that doesn't usually, those exact words, pick your own, may not even appear anywhere in the zoning ordinance. So you have to figure out what use are you? Where do you fit in the scheme of things in your zoning ordinance? Now, the permitted uses are what's also called permitted by right. If you are a permitted use and you're doing something that is permitted by right, you get the greenest green light you can get from the township to proceed ahead. You may need nothing but a review of your of what you're planning to do with the zoning officer, and you may end up getting your zoning permit right away, but I'll get to that in a minute. Now, uses can also in that district be listed as either uses allowed by special exception, that's one category, or conditional use, and that's another category. And that is, those are uses, things that you can do on the property that are not permitted by right automatically, but can be permitted if you go through a few extra steps, either with the township hearing, zoning hearing board, or the board of supervisors of your township. And so I'll talk about that in a minute. And then you have the dimensional regulations, as I mentioned before, that tell you the ticky-tack details of exactly what is required to be compliant with that use in that particular district in your township. And then the objective of this whole thing is, I should mention, you can have a deviation from dimensional requirements by what's called a variance. I'm not going to talk too much about that. That's a little bit more than we can probably tackle here. But okay, now objective of this whole thing is, easiest thing you can do is go into the zoning, or the easiest way this could go is you go to the zoning officer and say, hey, I want to do X, Y, and Z at my vegetable growing operation. And maybe you have some other supplemental activity or some other activities that go on there, but you know, you want to do pick your own or whatever it might be. And if it's a permitted use in the township and you review everything else that you're planning to do with regard to that, and you meet all the requirements, you may get your zoning permit right then and there. And that's what you're after, is a zoning permit that says, yes, you can do this at this particular location. Here's your document that says that. You're on your way. Now, you may end up, however, having to go through some more hoops than that in the form of maybe getting a special exception or conditional use, or maybe a variance from some dimensional issue that arises. This is what a zoning map looks like. You know, they're kind of, you got to expand them to really get the detail. The reason I'm showing you this is because this tells you, this was an example of something in, I think it was Potter County, way up somewhere. No, it wasn't Potter. It was a fairly rural northern county. Anyway, these are the different zoning districts down here in the boxes. And the reason that I'm showing you that is to show you how sort of vague, you know, this brown area is ag, this gray area, which you see here and there, that's commercial and industrial. That's how they're abbreviating it. This green is apparently what's called a conservation district, and we're not exactly sure. We have to look at the ordinance to see. These names can vary from ordinance to ordinance, from township to township. They are not set in stone by the MPC. They are what this township has decided to call its districts. Here we have this blue area that is a neighborhood and community, is I think what that NBH stands for. And then residential is the, so in other words, I think this neighborhood and community is probably a smaller business. That's not necessarily going to be appropriate for large commercial, but smaller commercial, downtown kind of district sort of thing. The pink is residential, pure residential district, and it could allow other things, but that's what they're calling it. And then this village residential is the yellow, which would be for sort of higher density, perhaps housing. That's usually what those, when they use that kind of terminology. Anyway, the point of all that is to show you that these are all kind of, these are relative terms that are being used. An agricultural district doesn't mean anything until you open the zoning ordinance and read what the agricultural district is or consists of or allows in that particular township. Agricultural districts across the state could be completely different from each other. So that, just because it says agricultural district, that doesn't really mean anything unto itself other than that's the name they chose. Okay, now, again, this is kind of what I just talked about. Terminology can differ and the formal name of the district is really irrelevant. The list of permitted uses and what uses are not permitted by right, in other words, what you have to go through some extra hoops to get approval for, that's really what defines, the district and what's allowed and what isn't, not a name. And uses themselves then, in other words, if you've got a zone, and I'll show you one in a minute, when you have a zoning ordinance and there's listed uses, or maybe and uses by special exception include, and then there's a list, you have to go to a separate set of the section, of the ordinance to find out how that use is defined. And that's the definitions section of the ordinance. So that's how you read the ordinance, is just because it says that, equine activities or residential horse boarding or something like that is, a use permitted by special exception, let's just say. You have to go and look up the equine activities or whatever the terminology is and see, okay, so how are they defining that? What fits that definition and what might disqualify something from fitting that definition? So again, it's all a question of reading the definitions within the ordinance. Nothing is universal across the state, or it's rarely universal across the state in terms of zoning terminology. Now, interestingly enough, agriculture doesn't have a definition in the MPC. Well, I shouldn't say that. There is a definition, but each adopting entity, each township, borough, city, etc., can define agriculture how they wish to in their ordinance. There is not a statewide definition of agriculture. I'll show you something in a minute that'll explain my hesitancy. There is an agricultural operation definition in the MPC for another purpose. So now, here's an ordinance example of how agriculture is defined. Use of land for farming, dairying, pasturing, horticulture, floriculture, viticulture, animal and poultry husbandry, and necessary accessory uses. That's important to understand. The necessary accessory uses for packing, treating, or storing the produce and equipment for housing and feeding the animals and housing the equipment. The use of land for a dwelling site is not an agricultural purpose. So the residential house, if you're going to live there, is technically an accessory use. That's a necessary accessory use to the principal use, which is agriculture. Now, there's something missing from this definition, and I will talk about it in a minute. Maybe you've already spotted what's missing in here. Now, this is the MPC's definition of agricultural operation. And again, a long narrative definition that basically includes just about everything about producing a commodity, and even a little bit about might say, here it is, harvesting and preparation for market or use of. Okay, and here is what we know of as the normal agricultural operation definition that comes from Pennsylvania's right to farm law and then has been used in some other laws. And now, note what was missing? Neither of these, nor that previous example that I gave you from an actual ordinance, none of them mention on-farm marketing or any type of, well, I should just say preparation for marketing. Yes, the actual retail sales, the actual marketing, not mentioned. That's very important to understand, because if there's one misunderstanding across the state with regard to agriculture and what Pennsylvania law says and doesn't say, and what municipalities can and can't do, is there are provisions where of certain laws where municipalities are not permitted to restrict retail or to prohibit retail sales of ag commodities from the farm. But that does not mean that the definition of agriculture would include retail distribution from the farm. So, the zoning, for zoning purposes, retail is essentially not part of agriculture generally. There might be an odd township here and there that keeps it in there, and we'll talk a little bit about some of these other places. There's very limited Pennsylvania law about townships' ability or restrictions on interfering with retail sales, but it's only the concept of retail sales. They can still dictate things about your setup and the building that it's in and those sorts of things. Just the concept of retail sales, if you comply with all the other things, can't be prohibited in certain instances, being in an ag security area, being on a conserved farm. So I just want to kind of put that aside. We'll talk about that next time. Okay, so you have to get the concept of principal and accessory uses. In zoning, generally in Pennsylvania, agriculture is a principal use, but it also can have many accessory uses, secondary other uses that are accessory to the main use on the property. So so that's a good concept to understand. Zoning ordinances employ the concept of farm-related businesses conducted on site as an accessory use. And this is taken right from an ordinance. Businesses in the ag district provide at-home employment opportunities that are intended to serve residents. It shall not become the business shall not become the primary use on the parcel. However, in other words, it's generally got to be the in this particular instance, anyway, this township. That language means that there has to be farming going on, not just selling produce. There has to be production of the produce. There might be requirements in the zoning ordinance as to how much of what's sold on site has to be grown on site. And the primary use of the parcel shall be, you see how it's worded, shall be residential or occupied farm use. In other words, you got to be growing the stuff yourself, or some percentage of it. Many times zoning ordinances will say. So there are various names for these farm-related businesses that become accessory uses. Sometimes they're farm occupations, sometimes they're rural occupations. These are other definitions that are used in zoning ordinances for the same kind of thing. In this particular one that I have an example of, their at-home employment is the word that they're apparently using in that one. In any event, so that's a concept to understand. Now let's go to an example of permitted use list. This is Warwick Township in Lancaster County. And it says, okay, in their so-called agricultural district, here's the permitted uses. Agriculture, okay, including one single family detached dwelling. So they give you one house contained on the site, including, and then agriculture would include, probably ought to be a comma in there, but commercial poultry operations and commercial livestock operations as defined, and that you have to look it up in the zoning ordinance. So that just gives you a general for this district, their definition of agriculture, that you'd go look it up and you'd go look up the commercial poultry and commercial livestock, and then you'd get a picture of what's included within this permitted use number one. Permitted use number two, horticultural and forestry related uses. Okay, and there would be a definition elsewhere in the ordinance you would look at. Municipal use, that's the township doing governmental activities there. So that's allowed as a permitted use in the agricultural district. In other words, it's a use as of right. Public utility structures. Okay, yeah. I got to put up power lines, or whatever else might be going on, sewer, or water or facilities, or could be pipeline facilities for that matter. Okay, and then this is a big one. Accessory uses customarily incidental to the above permitted uses, which means if particularly plain sect people, if they want to have a tack shop where they make things out of leather for their horse and buggy, that's a customarily incidental to the it's an accessory use customarily incidental to the ag use. And then if you get a lot of those, everything from machine shop, non-plain sect, you get, everything from machine shops to work on farm equipment to, lawnmower repair, to all of these things like that are customarily incidental to one of these other uses. And then they do have a little list of some of them. Roadside stands is one. And then this last one is just says that, hey, for any parcel that was in residential before 85, accessory uses are the ones that are permitted in the residential zone. So, okay, so that's an example when you're trying to read a zoning ordinance. Zoning is all about reading these ordinances. You have to read the stuff. There's no way to talk about it without that. Before the days of internet zoning ordinances where you get them off the internet, it's really tough because you had to go to the township and buy a copy of the ordinance. Okay, uses by special exception. That's generally the second category of uses that are listed in the zoning ordinance. And here's an example of them in the ag district. Bed and breakfast, okay, churches, commercial grain and feed mills, communication towers and antennas. We all know that in the 90s, ag producers made, a good bit of rental income from cell towers. Facilities for the sale, repair and service of agricultural equipment. Okay, kennels. Okay, we enough said about dog kennels. I spent years of my life involved with dog kennels, and that's enough for me. On-farm occupations, there's that accessory use of a farm-related type business. outdoor recreation without permanent buildings. In other words, it could be, again, it could be for a fee. Maybe it's, paintball. Okay, public and private schools having a total enrollment of no more than 50. I think that's I'm not sure why it says no more than 50. I think it's because they didn't want to, they had a different way of dealing with small schools. It wasn't a use by special exception. It could have been, it may be a use by right in this particular township. I don't know. Riding or commercial horse boarding, wholesale product sales, stockyards, buying stations. Okay, so that gives you the idea of these uses by special exception that are allowed. Now, again, that requires some proceedings to get the approval. It's not a use permitted by right. Now, use approval and by special exception or a conditional use. This is the extra proceedings that you have to go through. And so this is why I want to explain this to you. So in addition to rights to uses by right, those permitted uses, sometimes you're going to fall into one of the uses that's only permitted by special exception or conditional use. The zoning hearing board hears a petition, which you as the landowner would file, to approve a use by special exception, and it could be with or without conditions added, as part of the approval. Now, for Township Board of Supervisors is who hears a petition and holds a hearing on a petition that you as the landowner would file to get approval of things that are permitted by conditional use. The reason essentially for this division is that the zoning ordinance provides two levels, slightly more sophisticated perhaps at the secondary level, which means the Board of Supervisors. That's the legislative body of the township. The zoning hearing board is like a sort of a small judge's office or a small adjudicative, we call it quasi-judicial, it's lawyer talk for you, but it's essentially an office that decides basic requests from citizens. But if it's of a little bit larger gravity, let's say, has been designated that way in the ordinance, then it goes to the actual Board of Supervisors, which would be the equivalent of going to your borough council or your city council or the county commissioners, board of commissioners or something like that. So that's a distinction in a zoning ordinance that has been decided, it's been made by the drafters, meaning the supervisors of the township, in order to create uses by right, as long as you meet the requirement, uses by special exception. Okay, the zoning hearing board's okay to give out those, as long as they meet the requirements that we've put forth in the ordinance, or you got to go all the way to us, the supervisors, and get approval for these particular types of uses that we have designated as ones to be dealt with under a conditional use approval petition. All right, so there's these different levels of sort of sophistication or scope of inquiry, okay? Now, I'm going to read this for you because it's kind of important and I like the way that this is written. In designated uses permitted by special exception, or in designating uses permitted by special exception or conditional use, the Township Board of Supervisors have already made the determination that these uses generally are not contrary to public health, safety, and welfare, and that'll be important in a minute. Rather, they are permissible and legitimate uses within the zoning district. So don't let somebody tell you that, oh, well, that's not permitted because you have to get a special exception. No. It's been determined, or that's not allowed, or no, it's already been determined that it can be permissible and that it's not contrary to public health, safety, and welfare at this particular location. But their designation as a special exception or a conditional use subjects them to additional criteria and safeguards and a closer examination by a body, whether it's the zoning hearing board or the commissioners, or as I say, the supervisors, beyond the zoning officer. So at the first level, when you're doing permitted use by right, the zoning officer is the only one who's looking at all that, and it's clear enough, and the ordinance has made it clear that a zoning officer has the authority to grant the approval themselves for that. But these other things, no, you got to go through a slightly different process that's at a little bit higher level in the township hierarchy of things. So that's really that's what permitted uses are, special exception uses, and conditional use approvals. They are just increasingly more sophisticated review of a proposed thing that somebody wants to do at their property. And in writing the ordinance, that system is essentially designed. Okay, now, special exceptions and conditional uses are usually reserved for those land uses that will have a significant impact on the zoning district or the whole community, or for those uses that necessitate some type of additional safeguard. And so those safeguards, they are all spelled out in the zoning ordinance. There are specific standards for all of these special exception uses and these conditional use approvals that might have to be obtained. And the way it works essentially is the applicant is required to show that they're conforming to everything that's written in the zoning ordinance, and if you satisfy all those requirements, then they're entitled to approval of their petition. And then essentially the attention shifts to anyone who's objecting, and the objecting parties are generally objecting because these other things are very black and white. Either you meet the setback or you don't meet the setback. But these subjective standards are things like not detrimental to the general health. What's the exact words that were used here? To the public health, safety, and welfare. There's usually some kind of open-ended subjective criteria like that in a conditional use or a special exception. And that's where objectors can come in and say something, but they don't win the day just by saying something. They have to then convince the supervisors of the zoning hearing board that somehow this particular proposal at this particular location to do something that the supervisors have already said can clearly be permissible here, that this is somehow at this location in this way creating harm greater than normal for a use of this type. So that's really all. You just have to understand that if there are parties that are objecting under one of these sort of subjective health welfare type criteria, that they have a much higher burden because they have to convince the board or zoning hearing board of the supervisors that they have proven that this is unusual circumstance and that there's something different about this operation at this location than would normally be the case. Okay, now this is an example of I wanted to show you one since we've been talking about things a bit in the abstract. This is an example from a zoning ordinance that shows you how farm-related businesses are defined in the definitions section. So if you go through and you say, oh, well, look, I'm in the ag district, but I also want to have, a retail farm stand. Okay. Look through, okay, retail sales may not be, it's not within the definition of agriculture. We had looked at before, and it's not separately listed. Maybe it's, listed as a farm-related, or it falls into farm-related business, at this particular zoning district. So then you go to the definition of farm-related business, and here is what you'll see. This is a very typical type of definition that you'll see. It has lots of requirements. So this not only includes the basic use requirements, but also the requirements for buildings, lot size. These are the dimensional things, the setback, is there, outdoor storage? How much can that be utilized? And, does the owner have to, reside there? Here it says, yes, at least one of the owners of this farm-related business has to reside there. What kind of parking do you need? Well, it says you got to comply with section 313. So you got to go look at that. So that's how you figure this out, is you look at these definitions and you got to pick them apart, paragraph by paragraph, and see if you're satisfying them. Okay, so now that's zoning, okay? And I want to get to my other topics just to round things out and make sure that you're understanding. If you have questions, by the way, please put them in the chat. We do have a question here, which I will address in a second. Good to know, Phyllis, that you have a question. Thank you very much. Please ask questions. I'd love it if people would submit them. Okay, 3 more things I'm going to talk about. Pennsylvania's Uniform Construction Code. That exists. It was adopted in the mid-2000s in Pennsylvania. It covers the entire state of Pennsylvania unless a particular jurisdiction happen to be interested in adopting their own in some way, shape, or form, or having some type of deviation from the Uniform Construction Code as written and adopted in the rest of the state. And they can do that. Very rarely has that happened, however. Most townships have pretty much, gone along with the Uniform Construction Code as it was enacted by the state legislature. Now, it's enforced, however, of course, by the locals. So it may be the same zoning officer that you deal with on the zoning issues also does Uniform Construction Code, or it could be maybe they have a different person in the township that deals with the Uniform Construction Code issues. So this is essentially the regulation of your buildings insofar as they're going to be occupied in some way by humans. The worst case scenario is this is all about preventing a building from collapsing on you, or in some way otherwise endangering people that may be inside through some chain of events. The thing that you want under the Uniform Construction Code, and the thing that you're after in zoning permits is what you were after. It says, yep, it's good to do this at this location, or you're approved to do this at this location. What you're after here is your building permit. Or sometimes if it's not necessarily it doesn't need work per se, the zoning permit might cover it, or the township might have actually written an ordinance that provides a separate occupancy permit that is different than the zoning approval that says, yes, people can be in this building, transacting their business, for example. Okay. Now we have a poll up here. If you could fill that out, that would be great. Now, the one thing you might also need is you might need a construction E&S plan, erosion and sedimentation plan, if you happen to be doing any type of earth disturbance when you're going in there to deal with your Uniform Construction Code issues, which means, of course, that you have some building you're going to utilize and you have to figure out, is there anything that has to be done to it to be utilized in the way that you want to do it? Okay, now, why am I talking about all this? Because there is an agricultural building exemption to the UCC, the Uniform Construction Code. And here it is. And this is a wonderful thing. And it's been amended a number of times over the years. In fact, the first sentence, a structure utilized to store farm implements, or other agricultural, horticultural products, house poultry, livestock, other farm animals, a milk house, a structure used to grow mushrooms, agricultural or horticultural products. Well, just recently, what the words agricultural, I think maybe horticultural was the words that were just recently added, but that last little piece wasn't in there before, and the mushrooms was added at a later time also. So this is not some age-old definition. It has been revised over time. And then there's a thing in here that talks about members of plain sect getting an exemption as an agricultural building for carriage houses where they're storing their horses and buggies. And then it talks about, there's something about, maple sap harvesting. But this is the important sentence right here at the end that just puts a giant, fly in the ointment. The term shall not include habitable space or spaces in which agricultural products are processed, treated, or packaged. So that means if you're going to have people doing prep of your product in some way in the barn, it's not a habitable space where your employees are supposed to be processing, treating, or packaging agricultural products. And also, this is the big one, it shall not be construed to mean a place of occupancy by the general public. So not only, it doesn't include where your employees do work that is in the nature of processing, treating, or packaging agricultural products, but it's also agricultural building cannot be something that the public enters. You lose your Uniform Construction Code exemption, agricultural building exemption, if the public enters the building. So what's that mean? It means that all the barns you have out there in the world are theoretically not agricultural buildings if the public is entering them in any way, shape, or form, including, of course, wedding barns. So that's a whole thing unto itself. But the general rule, unless it is somehow allowed otherwise by the township, and you really have to work on wedding, to tailor down what you're doing inside the barn. But in any event, that is not that is not any kind of guarantee that you're ever going to be able to use your barn for a wedding. Let's just put it that way. You know, it's all going to go township by township, and the deck is pretty stacked against you. And as I said here, the language, a place of occupancy by the general public, means that allowing the public to enter an existing barn will require that structure to be fully UCC compliant. I cannot tell you how many times I've had producers contact me, either at the Department of Ag or here since I've been at Penn State, where they want to do some part of their retail operation that they're expanding into, or their direct sales, or their agritourism or agritainment. They want to do some tiny part of it, maybe in the barn, and that blows the whole thing up because the barn cannot be used without having potentially, you know, sprinklers or some other handicap accessible or whatever the situation may be. So I'm not an expert on the ticky-tack details of the UCC. Just understand that it's implicated. If I had one, for example, a flower growing operation where they wanted to teach flower arranging courses using the products there, then it'll help to sell, of course. And you know, they couldn't even sit around some, you know, folding tables in the barn and work on flower arrangements with an instructor in the barn because that was, you know, the barn was not UCC compliant. And that's a very, very significant problem in this Commonwealth right now, with beautiful historic outbuildings that cannot be utilized because of this exact issue. Okay, now there is a thing that I call the three-sided small temporary farm market exemption, which is you can have a farm market on the property that is not UCC compliant if, and this is one of the exemptions, no more than one structure per parcel. Structure is used for direct seasonal sale of agricultural commodities. The structure is open on at least 25% of the perimeter. So it's only got 3 sides. Or, you know, it's a rectangle, but it's only got 3 sides, open-ended on one side. That's why I call it three-sided. The structure is operated by a producer whose products make up not less than 50%. We talked about that before. And so that's the threshold. Got to be 50% or more of your own stuff being sold in there. And if it's not located on your property, then it's erected. In other words, it's not part of your farm. If it's located somewhere else, it has to be essentially only there for 180 days a year and taken down. So it has to be like a temporary. And the structure has an area of not more than 1,000 square feet. Well, 1,000 square feet is pretty small. So that's not much of an exemption for a farm market. One thing, it can't even be heated, you know, it has to have an open side on it. So, you know, that's problematic. I mean, this is not very helpful right now in terms of the way that the UCC exemptions, the ag building exemption and this particular farm market exemption are written. Okay, I'm going to skip over that one, just some definitions. Last 2 things, Stormwater Management Act. Can tell you also how many people have come to me saying, I went to the township and said I wanted to do this, this, and this, and they told me I needed a stormwater management plan for my high tunnel, my hoop houses. And people use those terms to mean different things, and that's exactly what I'm going to talk about. But there is this stormwater issue really is a problem with the high tunnels. There is a high tunnel exemption for stormwater management plans. It was passed in 2018. You think it's going to be, oh yeah, well, this should work, huh? You know, well, unfortunately, I'm just going to skip ahead for a minute and show you a graphic. Instead of the exemption working for these people and making sure they didn't need a stormwater management plan, the people on the left, and that's the kind of thing where you get hit with the requirement for a stormwater management plan, that's going to be more expensive than any other aspect of what you are trying to do here. But the exemption also includes this kind of setup on the right, which has, you know, a fairly impervious surface as the floor. And, you know, it may not be, you know, what we all call, you know, a simple high tunnel, you know, for growing. Now, of course, keep in mind, you can never have the public going inside your high tunnel. That is just not permitted under Pennsylvania law as a retail space, let's just say, where the public can go. So I won't go into all these details. The bottom line is what happened with the high tunnel exemption to stormwater management is that it got extensively eroded by all of the qualifications of what could be included within a high tunnel, including things that have a floor that are made of pavers or a floating concrete slab, like I showed in that picture. So that, yes, this exists. Is it working in practice? Not very well, because townships are very defensive about giving out waivers of stormwater management plan requirements when something like this can get the waiver. So that's what has happened with that. Last thing, what we call subdivision and land development ordinances. Last thing under the MPC, and we'll be done. I'm sorry to run over a little bit. Every township that has a zoning ordinance generally has either a township subdivision and land development ordinance or a county version of the same thing. And sometimes you can get caught up into something where the zoning officer tells you the first time you meet with them, or you find out later, all of a sudden the township's saying, oh, to do what you want, you need a land development plan. Okay, you just have to consult the individual ordinance to read all of its provisions. There's a definition of what a subdivision is, and I won't go into that, but land development can trigger the requirement for a land development, or the definition of land development can trigger the requirement. And here is the definition. Rather than go into that in detail, I will just tell you it's here in my PowerPoint. Get that. I want to answer the questions before we get too over time. Questions in the chat. Must we refer to vegetables and fruit as specialty crops? You don't have to, but that's what we're referring to it here in this webinar. Is that seems to me they are central to healthy diet, shouldn't be termed an extra. How about we call them essential crops? That's a USDA term, specialty crops, to talk about things that are not row crops, etc. That's their word. Other things certainly can be used. That's just for certain programs you have to use that word so that people know what you're talking about. Another question, how would this definition apply to a methane collection electric generation facility on a solar farm? Those generally are judged as to their permissibility by a definition, if there is one in the zoning ordinance, that talks about what's the electricity being used for. The electricity is being used to sell back to the grid, a net metering type of situation. Generally, that's going to be not considered depending on that, not going to be considered usually a farm related business. That may particularly if you're not using at least 50% of the electricity on site. I guess the bottom line to this one, Tim, is there's different answers to different fact patterns. But the way that the solar farms and the solar development that's going on in the state is going is that most ordinances don't have specific language. So it becomes a conditional use approval petition that gets filed with the supervisors. And then that becomes a long drawn out series of hearings all about this solar generation facility, because it's not for the landowner's use, it's for commercial distribution to the grid, essentially. And that's essentially a commercial business. That's the commercial generation of electricity. Okay, doesn't the control of runoff from a high tunnel still need to be controlled on the property per the Act 1? Yes, that is true. And I think I had it's in that, and that's why I just didn't quite have the time. It's buried in the language here. Let's see. It's here. Yeah, right here. This little one, 2 and then 3 little I. Even if you are exempt, you still have to do this, which support the high tunnel with a buffer or diversion system that does not directly drain into a stream or other water course by managing stormwater runoff in a manner consistent with the requirements of this act. Well, that sounds like you just about reintroduced the requirements of the act back in. You gave them an exemption, and then it's almost like you took it away. So in answer to your question, Garland Treese, you have a very good point there. It's not that they still need to be controlled on the property per Act 168, but that's part of the definition, and townships have been taking very broad liberties with that little piece of language that I just showed you. Last question, Phyllis. Oh my goodness, Phyllis, you're filling us up here. This is great. Are the huge indoor facilities required for growing medical marijuana? No, they are not, because while cannabis with a 0.03 or less THC level is considered an ag commodity. Marijuana with those higher levels is not. So the growing of marijuana in any context is never inside an agricultural building. And it's not an agricultural commodity. How about the giant greenhouses used to hydroponically grow salad greens indoors? Yes, those clearly now. And what's happening there is those are being built, very, very, very high tech, and with construction methods and everything else that is fully UCC compliant. I can guarantee you none of those things are getting any type of agricultural building exemption, because as you will recall, it's the agricultural exemption doesn't apply if it's any place that you have your employees doing things like processing, packaging, etc. Now, last question: are there plans for revising the code? To make it more amenable to year-round farm market sales? That would be good, wouldn't it? And I'm very hopeful that that does happen. And that's part of the reason why I explained all of that to you, because you people should be the standard bearers for that, which is this. I'll go back to it again. Whoop, for a second. This definition for the agricultural building exemption to the UCC needs some attention. Let's just put it that way. And so, yes, that is that would be a good prospect. Whether it happens, I don't know. But that would certainly be something that would be of great assistance to our ag producers in the state. How can we make that happen? Talk to your legislators. Get the attention of the House Ag Committee members or Senate Ag Committee members. Or staff of either of those committees in the General Assembly. And that's kind of where the process begins. All right. So having answered all of the questions, please keep in mind that we have a poll, and there is a link to the poll in the chat function. So please go there. We really implore on you, could you please fill this poll out, because it's really going to help us get feedback on these educational programming, on this educational program that we do, and can give us ideas for future things. So we'd love to hear from you. And this survey is, sorry, yeah, I called it a poll, it's a survey. We just talked about this morning. The poll is the thing we do during the event. The survey is what we ask you to fill out after the event. So there's there is the link to it. Please hang on the line here and fill it out now if you can. We'd really appreciate that, because that feedback is just so important to dictating where we go with this. And keep in mind that this set of 6 webinars that we're doing in this series will always be available to you. And as attendees, you're going to get a booklet form that will be all of this material in a booklet format as we complete out this entire webinar series. Your input now is going to help with that, as well as with future series like this, particularly, specialty crop, the USDA specialty crop block grant program administered through PDA for their portion is how we're doing all of this. And we'd love to do it regularly. So specialty crop producers have unique needs. We're there for you. All of our contact information is available on our website. You can contact any of us. It's it's not www, just aglaw.psu.edu, and has that HTTPS in front of it. But if you just put in aglaw.psu.edu, boom, you'll get to our website. All kinds of stuff there for you, including about us, and then look down. You can get all of our email addresses, send us your questions. Love to hear from you. All right, everybody, we're 9 minutes over. Thank you for those extra 9 minutes of your time. Really appreciate everybody attending. And I see that we did a pretty good, everybody hung in there with us. So last event is coming up in 2 weeks, I think it is. And that will be about some of the special protections that agricultural operations get under Pennsylvania law that we haven't talked about yet. All right, have a good day, everybody. Thanks a lot for attending.